Okay, let's get started. I'll let our guests introduce themselves. My name is Bill Fair. I'm the Director of Public Policy and Communication for the ACLU of Virginia.
I am Claire Guthrie-Gastagnaga. I'm the Executive Director of the ACLU of Virginia.
And I'm Charlie Schmidt, Public Policy Counsel for the ACLU of Virginia.
And phone, it says live video interrupted.
Oh, it's back.
It's back. Okay,
Okay.
Great. So we are all members of the legislative team for the ACLU of Virginia and working hard at the state capitol every year to try to promote positive changes in laws related to civil rights and civil liberties and to defend against laws that would attack those rights. So this session was quite a busy one. We had a 6-week session that was largely taken up with budget matters, but of course we did have bills, good and bad, on an array of issues related to the ACLU of Virginia's mission. So today we're going to, because time is limited, we want to talk with you specifically about 4 bills that we're asking the governor to veto, that passed through the House and Senate this session and that we believe that he should strike down. So I'll start with Charlie.
Let's help people understand the process a little bit. I
Go
think
ahead.
it's just important.
Mm-hmm.
Our session ended on February 27th on Saturday, and the governor has 30 days from the end of the session to decide whether to amend or veto or sign any legislation that passed, and that means that he has to get done by midnight on the 27th of March, and then the General Assembly comes back into town on the 5th of April to look at what the governor's recommending, and they can accept governor's amendments if he sends them down, or he can reject them, and then he has a chance to decide whether to veto the bill if they don't like his amendments, or they can override his veto with a 2/3 vote. So we have a bunch of work to do between now and the governor's deadline to make sure he knows what we think, both as the ACLU and you as members, about some things that passed the Assembly that we do not believe should become law.
Great, thank you for that. It is important that people understand the process before we start talking about the specific issues. So the first one that we want to talk about is House Bill 1468, which has to do with ICE detainers. And I'll just ask Charlie to talk a little bit about what this bill is about. What does it seek to do?
Sure. Well, it's a little bit of it's a big concern for us because the bill has a bit of a circular argument in it. It creates a bit of confusion, and we feel it is unnecessary message bill. There were several of these this year targeting immigrant communities and refugees in particular. These were similar bills to last year, and we see this sort of rhetoric building against new arrivals that concerns us. Specifically, House Bill 1468 goes to detainers, and for those out there, we're dealing specifically with detainer requests that come from ICE, Immigration and Customs Enforcement agents working on the ground in our communities, seeking out folks that are undocumented and subject to removal. Basically, our concerns with the bill is that it creates quite a bit of confusion between the requirements of the law and requirements in protecting civil liberties, and requests that come from ICE towards a particular individual. Most notably, I think our real concern with 1468 is that it's already creating confusion for local law enforcement. And just to give you a little background, an ICE detainer will come down from an ICE agent to a local law enforcement. That person has already been confined.
Can we do a little crayons again?
Yeah.
Okay. So a detainer can be one of 2 things. It can be something called an administrative warrant. That comes just from ICE. It doesn't nobody goes to a court, nobody gets a judge, nobody has probable cause. They basically say, we kind of think we want to explore whether this person should be in the system for enforcement purposes, so we hold on to them.
Right.
The second kind is a document that comes with a court order attached signed by a judge, which means they went and they said, we have probable cause to believe this person has committed a criminal violation of the immigration laws. And it's really important to know the difference, because if you hold somebody in jail past the time when they were supposed to be released on the first one, which is just the administrative request, it's unconstitutional. If you hold them on the criminal warrant, which would be just like a criminal warrant from Maryland, for example,
Right.
then, you have process and due process as attached. So I think it's just, again, sometimes we jump forward in our knowledge base.
Oh, yeah.
So I wanted to,
And it is
color the coloring book a little bit.
Right. And it is a very convoluted and complex process that I think gets lost in the arguments against these things. There's been case law and as well as Attorney General's opinions that say these administrative warrants, as you said, are requests from ICE officials, that sometimes they're based on nothing more than a hunch by these federal officials. And what's happening is if those come into local law enforcement, we've already heard confirmation in the news. Fairfax County, for instance, on their website says they hold individuals 72 hours past when they're supposed to be released for the original arresting.
But I mean, there's an example of confusion.
Yeah.
Because they use the word detainer.
Right.
And we don't know from reading the website whether they mean an administrative detainer or one
Correct.
that's backed up by criminal process.
Correct.
And again, holding somebody 72 hours beyond their term on the first kind would be unconstitutional.
Right. And it could potentially create confusion between, let's break down a very simple scenario. Someone is picked up on a DUI arrest. They get arrested anywhere in Virginia. As soon as you're arrested, you're basically pinged, and your status is sent up to federal databases to check to see if there's.
Because we have a law that makes them do that.
Right.
Yeah.
So if you have a detainer attached to someone that's arrested, then ICE is notified automatically. They're on notice that you've been picked up and you're arrested for DUI. In Virginia, obviously a DUI, a judge has the power and to release someone either on a personal recognizance bond or bonding out for, say, a minimal amount in order to be released until your court date, until the time actually comes. So this bill, HB 1468, potentially creates confusion for the local law enforcement, basically the local jail official, to say, well, a judge has ordered this person be released on a personal recognizance bond for just a simple DUI, but now I have this law that says I can't release them except to federal officials if there's a detainer placed on them. So what does that jail official do in that instance? That creates the confusion and our concern for either violating a court order from a judge and potentially infringing upon the individual's constitutional rights, or following a detainer that is a request and potentially not backed up by, as you said, a criminal warrant to hold that person. So we're really confused. We're really concerned about this rather confusing law, and so as we said, we put a letter into the governor to veto it.
Yeah, I mean, bottom line, either it doesn't do anything, in which case it's just meant to send a message of inhospitality to people in the immigrant community, or it does something, which is suggest to sheriffs that they can hold people when they can't, and when it would be unconstitutional for them to do so.
Right.
Neither of those are good results, and so we really want the governor to just veto this one.
Okay, so, and we'll talk toward the end of the session about specifically what you can do to help with this effort. So, shifting gears, and the 5 issues that we're going to talk about today are all, quite different. The second one we want to talk about is House Bill 1791, which we view as part of a national trend, really, to quash free speech. There are a lot of folks out there exercising their right to free speech right now, and certain individuals and groups may not like that. And so there's a movement to establish enhanced penalties for certain activities related to free speech with the intent of chilling free expression and protest. So, Charlie, would you talk a little bit about 1791? And this is one of a slew of these bills that came before the legislature. This one actually passed.
Yeah, and it's like 7 or 8 or other states where similar things are going on.
Even more now. So this is, as Bill said, this is a national trend to put enhanced penalties on protesters, whether it's even peaceful civil disobedience, or in this instance, if something erupts into a more contentious or riotous act. Again, we're dealing with in Virginia, these are already crimes. I mean, this is it's already a crime to incite or a riot and that sort of thing. So again, Virginia is not in danger of letting anyone go that or not charging people for these crimes. The problem is for 1791, if you're currently, the way the law is written, if you conspire or you work with or basically lead a riot and incite a riot at a protest or demonstration, turns violent or uses force, you can be found guilty of a Class 5 felony. And Class 5 felony carries up to 10 years in prison, but there's not necessarily a minimum.
It's not a mandatory.
Yeah, there's not a mandatory minimum on there. That a judge could see it as well. This was an extenuating circumstances. It was a protest that got out of control. You're not going to be subject to prison time. You can serve jail time or no time and be on probation. Currently, so that's the way the law stands. 1791 proposes to carve out an exception such that if the riot is directed at first responders, law enforcement, firefighters, members of emergency medical services, then the penalty jumps to a Class 3 felony, which is up to 20 years in prison and carries a 5-year mandatory minimum sentence. A lot of these bills that were proposed and this one that passed is seeking to cure a problem that's not out there. We don't feel that this is a serious enough issue that we haven't seen an uptick in sort of these crimes being committed. Again, Virginia protects its first responders already. There's plenty of enhanced penalties in the
kind of
law.
a combination of two trends. One is these Blue Lives Matter bills,
Right.
which seek to enhance penalties, which we have already had on the books for 2 decades. And then this other kind of corollary, which is to suppress free speech by raising the penalties. I think the thing that bothers me most about this bill, frankly, is that, it's hard to say who's going to be a leader. Like if I organize an event on Facebook and it's meant to be a peaceful protest, but it turns, quote, riotous in this way, do I end up being prosecuted, under this statute?
I think there will be a trend that police will look to those organizers as sort of, well, here are the ones that we're going to pin as sort of the leaders of it. But just to give you a contrast to that, if you organize the event and it becomes riotous, you're subject to potentially 20 years in prison, 5 years minimum in prison. If I am participating in that riot and out there causing destruction, I'm only subject to a Class 1 misdemeanor, which is less than a year in jail. So that stark contrast is just way disproportionate and totally out of the realm of where Virginia should be going with its criminal justice reforms and protecting free speech and dealing with real problems that crop up as far as public safety, not perceived problems.
Right. Well, yeah, because we haven't had any situations in which people have done things that were criminal acts where they weren't prosecuted and got jail time. Like the guys that blocked the I-95, the interstate, and under existing law, went to court, got jail time. So they really, again, it's one of these message bills, and it's kind of like part of the session always looks like deja vu all over again, because we end up revisiting the same issues over and over again because people keep wanting to send the same message, whether it's a good one or not. And the two I want to talk about are exactly that.
Let's do that. So moving on, next one we want to talk about is House Bill 2025, which deals with solemnization of marriage and basically allowing the use of religion to discriminate against. Go ahead.
We had these bills last year, and to his credit, the governor vetoed the bill last year, and so I'm quite hopeful he'll veto it again this year. And we just need you to help us make sure he understands that we all care about him doing that. These are bills that elevate one set of religious beliefs over everybody else's. They say that if you believe that marriage is between a man and a woman, then you should have certain protections and certain rights to enforce that belief on others that you don't have for any other religious belief. And so they're not just about giving a license to discriminate, they're about elevating certain beliefs over others in a way that's a violation of the Equal Protection Clause and arguably the Establishment Clause of the First Amendment. So, this is a pretty straightforward thing. When you look at it, it says you shouldn't be forced to participate in the solemnization of marriage. Well, the ACLU is very clear about that. No minister, no religious congregation should ever be compelled to marry anyone that they don't believe it would be appropriate to marry in their particular religious belief. So, if they don't believe in interfaith marriage or those. So the First Amendment says that pretty clearly. We also have, a statute of religious freedom that was Thomas Jefferson's, and we have a Religious Freedom Restoration Act in Virginia, and those very clearly set barriers to doing things that burden people in the free exercise of their religion. So government couldn't, take an adverse action against that church for deciding it didn't want to marry two people. But government can say to somebody who is operating in the commercial sphere, you have to operate in a non-discriminatory way, because that's not your religion. That's not practicing your religion. So this bill, kind of jumbles everything up together, and part of it does stuff that we don't need done because we already have the law, and part of it does something that we object to inherently, which is to license people to discriminate against LGBT folks in Virginia.
And people are defined as religious-based organizations,
Right.
including the for-profit subsidiaries of those, like
sure.
say a hospital.
Right. Oh, yeah.
So,
allows denial of services by hospitals, by potentially shelters, other
daycare centers.
Daycare centers, things that are associated, loosely with a religious entity and want to be able to impose their religious beliefs in the context of their commercial activities.
Right.
So, and then the other one is back again this year. Has to do with how school divisions deal with controversial materials, and we have a law on that, and we have standards of quality, and we have model policies on how school divisions are supposed to deal with controversial materials, and the model policies call for there to be a process where a parent could raise the issue of whether a particular book or assignment was appropriate, and that there would be alternative assignments if possible. So again, a message bill, because we don't need any more process than we already have. We have some school divisions who don't understand the difference between prior restraint and making it an informed decision about educational materials, and so the good policies don't take the book off the table when somebody raises one of these questions about controversial material. But they have a process where you can raise the issue and you can get a judgment and a decision made, and then you can make your decisions as a parent, what you want in terms of the learning for your child. So what this bill does is it says that local school divisions, local school boards must have a policy in place where they review all the materials that they use in their curriculum to see whether any of the material is, quote, sexually explicit, and there's a new definition in the statute we hadn't seen before of what sexually explicit is. And then they're supposed to provide an affirmative notice to every parent that this material or that material going to be used in a course is sexually explicit, and then there's a whole thing.
But even with the definition of sexually explicit is a very broad, very vague
yeah.
term
Yeah.
That would result in many books being red flagged or just simply not even being used in the first place.
Right, and this all started with a book called Beloved by Toni Morrison, which is a prize-winning piece of literature, and one parent decided that she didn't like the fact that her child was reading this literature because it portrays accurately what happened in the life of a person in the South at a certain period of time, which included rape.
Right.
And so one of the things that people who are advocating these kinds of bills don't remember is not every parent sees everything the same way. And so the processes that are now in place protect every parent and every child in terms of securing them the right to see and learn in an environment in which inclusive of all materials, and having one parent's point of view dictate the curriculum is in derogation of all the other parents' rights. So when people talk about this as a parents' rights bill, it's about a parent or some number of parents, but it's not about parents' rights generally, because it seeks to take away from some parents the right to make different choices. So we have joined with a national coalition against censorship that includes a range of organizations from across the country, teachers and librarians and civil rights organizations and literature organizations and faith-based organizations, in opposition to this bill, and the governor vetoed it last year and said that the Board of Education was going to be looking at these issues. The board did look at the issues and decided that we didn't need to do anything more, and so the governor should veto this bill as well.
Okay, so we're asking for all 4 of these bills to be vetoed and letters going to the governor to that effect, and we would certainly ask for your support on that. And the best thing that you can do to help with that effort right now is to go to our website, ACLUVA.org, and sign up for our action alerts. So we'll be issuing action alerts on these 4 bills, which will allow you the opportunity to go online, fill out a very simple form that sends a message directly to the governor asking them to take this action.
Yep.
And very, very important that you do that, and you'll continue to receive email and action alerts from us on into the future. So the last thing we wanted to talk about is voting rights, and there was a lot in the news over the last 12, 14 months
Right.
about restoration of rights
Right.
to people formerly convicted of felony offenses, and so there were a number of fixes or things that were kind of portrayed as reform bills,
Right.
none of which, with the exception of one that we put forward, were any good.
Right.
So talk about kind of where we are now.
Well, I mean, I like to say this is the first day of our campaign to include a right to vote in the Virginia Constitution. You know, when the founders wrote the Virginia Constitution and our national Constitution, they really didn't want everybody to vote. You know, black people weren't people they wanted to vote, women weren't people they wanted to vote. And so there is no right to vote in either the U.S. Constitution or our Virginia Constitution. And we think there should be, and we think that that right to vote should attach when you reach the age of majority, which is now 18, if you live in Virginia, if you're a U.S. citizen, and if you have registered, and that it should be yours. It's the fundamental currency of democracy, and government shouldn't be able to give it to you and take it away. We currently have in our Virginia Constitution, we're one of 4 states in the nation where you lose your right to vote permanently if you commit a felony of any description. I mean, stealing a $5 chicken is a felony, guys. And then you can theoretically get it back, but only if a governor has a program of restoring rights that is inclusive and follows certain guidelines. Now, over the last 10 years, we've been successful in convincing governors to open the door pretty wide, and this governor has gotten close to 200,000 people, who's over 100,000 and moving up to 200,000, whose rights have been restored even after the back and forth about the lawsuit and his power and all that other stuff. So we're now at a point in time when the legislature looked at some amendments that they might propose to the voters. And our cycle is such that we can't go direct to the ballot. We have to go through legislature, and the fact that they didn't do something this year means the next time something could be put on the ballot is 2020. But you know, the proposals this year were meant to constitutionalize what I believe are voter suppression.
I mean, the worst of those for people convicted of a violent felony, they would never be able to
get
vote
their
again,
right.
ever. They couldn't
Yeah,
ask the government to get that right back.
convicted of voting fraud, never get their rights back. The
Or
last
they pay their
proposal,
fines and fees.
well, the last proposal said you have to pay all your, not just your fines and fees, but your restitution, and you have to complete that and wait 5 years.
Right.
You know, if you're a
Just
violent
because.
felon, just because. And you know, look, we used to have these requirements that people pay a certain amount of money to be able to vote, and those were set aside as poll taxes. Fines and fees are basically government-imposed user fees for the cost of running the system. And you know, frankly, I think voters should be willing to pay for public safety out of general fund dollars as opposed to charge all these fines and fees, which are exorbitant, excessive, and very hard for people of limited means to pay. But what they wanted to do was put that in the Constitution, something we've gotten governors to put aside, which is the requirement that everything be paid off before you can vote again. Now, nobody is saying that those lawfully imposed, I mean, we don't think they should be imposed, but they're lawfully imposed fines and fees or court-ordered restitution to the victim should not be paid. It should, right? But the question is whether you should have to pay it off, like a mortgage on your vote. Right? Before you can vote. I mean, when you mortgage your house, you get to live in it, right? You're paying it off, and as long as you pay off the mortgage, you get to keep living in your house. Well, what this does is say you have a mortgage on your vote, but until it's fully paid off, you don't get to use your vote.
If ever.
Yeah. And if you are a person of limited means, that might mean that you're forever foreclosed purely and simply for financial reasons from ever getting your civic rights back.
That's why we see it as a poll tax.
It's a poll tax, and nothing more, nothing less. So we've decided that, let's stop futzing around and talking about who should be able to get their votes when and how and whatever, and just say, you know what, the right to vote is fundamental. It should be everyone's. You shouldn't lose it, and it should be you should be able to vote regardless, because it is the fundamental currency of democracy.
Sounds pretty simple.
I think so. I think it's a lot easier to talk about.
Okay, well, look forward to hearing more about that. I think that covers the things we wanted to talk about. We hope this has been informative. I don't see any questions, so we'll go ahead and close, but feel free to reach out to the ACLU of Virginia through Facebook at any time with your questions, and I think you'll find we're pretty responsive and eager to engage with you. Once again, thanks for joining us for Facebook Live, and upcoming topics will include immigration, and we'll be having another event just prior to March 28th, which is the date of oral arguments in the Gavin Grimm versus Gloucester County School Board case. So thanks again. Please pass the word about the ACLU of Virginia.
Thank you.